The Supreme Court is set to hear a case that could have far-reaching impacts on how cities treat people who are homeless. The case involves whether local jurisdiction, whether they can enforce laws to curb encampments. A community in Southwest Oregon wants to make it illegal to sleep on public land, but the plaintiffs in the case say that's cruel and unusual punishment. Now, it's a complicated issue as cities cope with surging homeless population and calls to increase public safety. Our Jose Martinez talks to an advocate, a former Supreme Court clerk, and a man who has called the streets of San Francisco's Tenderloin his home for the past 25 years.
Anthony has called the streets near Larkin and Ellis in the Tenderloin his home for the past 25 years.
I came from Los Angeles, pretty much did my own thing.
He is just one of many homeless individuals whose lives could be impacted by a crucial decision awaiting the Supreme Court's ruling in the case of Johnson versus Grants Pass. The outcome of this case could have far-reaching implications for homeless individuals like Anthony, who rely on public spaces for survival.
It's already tough enough being on the streets as it is, you know what I mean?
On Monday, the Supreme Court will delve into the legal aspects of penalizing homeless individuals for activities like sleeping in public. Professor Rory Little from UC Law San Francisco sheds light on the case's significance and potential impact.
Will address a very narrow question, which is there any constitutional status at all for people who are homeless? And can you criminalize behaviors that the homeless must engage in, such as sleeping in public?
The case, originating from Grants Pass, Oregon, raises national concerns about anti-camping ordinances and their effects on homeless communities, and whether it can be considered cruel and unusual punishment to cite people for sleeping in public, even if they have nowhere else to go.
And this law was attacked by a number of people who are homeless as a class action on behalf of all the homeless, not just in Grants Pass necessarily, but similarly situated around California and the country. And the district court dismissed their lawsuit, but the Ninth Circuit Court of Appeals, which is the federal court that covers the entire Western United States, reversed that and said, no, these people have a cause of action, and laws that criminalize the status of being homeless are unconstitutional.
Professor Little emphasizes that regardless of the court's decision, the case prompts municipalities to reevaluate their approach to homelessness amidst rising statistics. The case comes at a time when homelessness is on the rise across the country, with a 12% increase reported between 2022 and 2023, according to a Department of Housing and Urban Development report.
I think the court is likely to say not everybody who sleeps on the street is involuntarily there. And they're going to say that municipalities have to sort of pick and choose and have to make individualistic determinations on almost every person.
Professor Little says we should expect a ruling by the end of June. For now, Anthony will stay here on the streets, hoping for the best.
I don't think the city should vote like that. Like, we shouldn't find nobody to just be on the street just because they're on the street.
For an idea of the scope of the issue, according to the latest available numbers from San Francisco, as of 2022, there were more than 7,700 homeless people in the city, with less than half of them in some kind of shelter. 2023 data showed around 6,200 homeless people live in San Jose, with only 30% of them in a shelter. And Oakland's data, well, it's only updated through 2022, but it shows a similar trend. Less than half of roughly 5,000 people were in some form of a shelter.